Hello, I'm Professor Fordham, and this is a short introduction to cause and fact. What I'm going to do is I'm going to start by talking about but-for causation, which is the major test for cause and fact. We'll start by talking about how to frame the question, and then we'll talk about two exceptions to but-for causation. After that, I'll discuss how to analyze probabilities with but-for causation. We already discussed but-for causation and cause and fact when we were studying products liability. What we're going to do now is dig into it a little bit deeper because it becomes more complicated when we do it with negligence. There's one key, though, as we go through this to make sure that you keep in mind. And that is to make sure that you always apply the general rule before you apply any exceptions. So you first want to apply but-for causation, and only if but-for causation isn't satisfied should you go on to any exceptions. So let's say that you see a fact scenario, and you see, hey, that looks exactly like a loss of chance fact scenario, or that looks like a perfect fact scenario for alternate liability. What should you do? You should first apply but-for causation, because most of the time but-for causation will be satisfied, and you don't need to get into the burden shifting and such that happens with the exceptions. And also, you're more likely to mess up the exceptions if you haven't properly analyzed but-for causation. So that is the key. So when we were talking about products liability, we talked about the general rule of but-for causation for cause and fact. We said a product defect is a cause and fact of plaintiff's harm if the harm would not have occurred if the product had not been defective. And so what we did is we compared what did happen when the product was defective to what would have happened if the product had been defect-free. What we're going to do with negligence is not much different. We're just going to say, okay, was defendant's negligence a cause and fact of plaintiff's harm? Essentially, we'll compare what did happen when the defendant was negligent with what would have happened if the defendant had not been negligent. And also, like in product liability, the standard is more likely than not. So plaintiff has the burden of showing that more likely than not, defendant's negligence was the cause and fact of her damages. So we've talked some about misfeasance and nonfeasance. Misfeasance being when somebody takes an affirmative act that is negligent, and nonfeasance being when somebody should take an act or should do something and fails to do it. Both kinds of negligence can support but-for causation. If somebody did something they shouldn't have, you would frame the question as, if defendant had not blank, would plaintiff have suffered blank? And the first blank goes the negligent act, and then the second one goes the harm. If defendant had not been driving drunk, would the plaintiff have suffered broken back in the car accident? You could also apply this when somebody failed to do something. Very similar. If the defendant had, and there you would put the untaken precaution, would plaintiff have suffered the harm? So if the defendant had warned Tatiana Tarasoff that somebody was going to try and kill her, would the plaintiff have suffered the assault from Podar? So you can set it up either way. Basically, you want to ask, it's essentially asking, but for the negligence of the defendant, would the plaintiff have suffered the harm? Now, we talked about this with when we talked about breach, but I wanted to bring it up here again when we're talking about cause and fact. As you know, somebody falls down some stairs. There's two ways of looking at it. There's the perspective before they fell down the stairs, when you saw them teetering at the top and you thought, wow, that person might fall down the stairs. And then there's the ex post perspective, when you're afterwards, when you say, well, that person fell down the stairs. Your perspective beforehand might be different than that afterwards. When we're analyzing breach, we're looking at the situation from the defendant's perspective before the accident. So we ask, when we're doing a hand analysis, what a reasonable person in the defendant's position before the accident would have done. Would a reasonable person have jumped in to save the plaintiff? Or would a reasonable person have thrown a log to save the plaintiff? What would a reasonable person have done, knowing what the defendant knew at that time and being in his position? Cause and fact, you can use hindsight bias all you want. Cause and fact, we're looking at it afterwards. And what we're saying is, okay, you threw the log. Is that what hurt her? Is that what hit her in the head? Is that what caused the concussion or caused her to drown? So one way to look at cause and fact is to look at the facts of New York Central v. Grimstad. In that case, as you know, Mr. Grimstad was on a barge with his wife. They had rented the barge from New York Central, and the barge got bumped by another boat, and Grimstad fell off the boat into the water. At that time, his wife ran to try to get a flotation device to throw to her husband. She searched around, and I think she went down under the barge, but by the time she came out, he had already gone under the water and drowned. So we can do a regular negligence analysis here. Did the defendant owe plaintiff a duty? Well, the defendant rented the barge to the plaintiff, and so there is a duty to tell the plaintiff about any hazards about the barge and to adequately equip the barge. So there is a duty. Next question is, did the defendant breach that duty? Essentially, we ask, would a reasonably prudent person or company rent a barge that doesn't have life-saving equipment on board? Now, you'll notice that essentially when we do the breach analysis, we're saying that the defendant should have done something that the defendant didn't do. Like, we're saying the defendant should have taken a cab instead of driving drunk. The defendant should have yelled to the plaintiff's friends rather than throwing a log for her to float on. In this case, the plaintiff was saying, well, the defendant should have supplied life preservers on the barge so that if somebody fell off, he had something to throw to them to save them. And that sounds pretty good. Does sound like that seems like a reasonable thing to put on your barge to have life preservers. And so she was successful in establishing that there was a breach of duty. The next question is, well, was that breach the cause and fact of plaintiff's harm? So we set that up. If the defendant had supplied life preservers, would plaintiff have suffered the harm? So we used the same untaken precaution as we used in the breach analysis down here in the cause and fact analysis to see whether it would have made a difference. Now, Mr. Grimstad did not know how to swim. So when he fell in the water, and she went to go look for something to throw to him, even if there would have been life preservers, and it would have been readily accessible, he probably would have drowned anyway, because he didn't know how to swim, and apparently that's the way things were set up in the dock at that time, that there just wasn't any other way to save him. And so even though the railroad had a duty, and it breached the duty, that breach was not the cause in fact of plaintiff's harm, because even if they would have done everything right, if they would have had life preservers on there, then he still would have drowned. Now, this is a problem, of course, for the plaintiff. They're thinking to themselves, well, we got past the first two elements of cause of action. You couldn't get past that third one. Maybe we did something wrong here. Maybe what we should say is, instead of saying they should have had life preservers on board, we should say they should have had a netting all around the barge that extends out a couple of feet all the way around the barge, so if anybody accidentally falls off the barge, they land in the netting and they're safe. They don't fall in the water and drown. Let's try that. Okay, so now they say they breached the duty. They should have provided netting around the whole barge, and if they had provided netting around the barge, would plaintiff have suffered the harm? Probably not. If there would have been netting all around it, the plaintiff would have fallen off the barge into the netting, his life would have been saved, everything would be hunky-dory. So why didn't they claim that? Well, the problem is, back up in breach. If they're trying to argue that the defendant should have provided a netting all around the whole barge, they're going to have a hard time showing that that was a reasonable thing to expect. I mean, if you put a netting all the way around a barge, it's going to be hard to tie up the barge, it's going to be hard to load the barge, it's going to be hard to do much of anything with the barge. And so, what might be reasonable, or what might be helpful to use a cause of fact analysis is not always the same as what you might want to argue breach the duty. So lawyers are in this position where they need to come up with an untaken precaution, or something the defendant should have done that a reasonable person would do. But if they make that too soft, if it's not something that would have really made a difference, then they can win on breach and lose on cause and fact. And the inverse can happen. If they push too hard on the breach element and say, well, they should have done all of these different things, they'll lose on breach even though they could win on cause and fact. The one thing to notice here is that whatever you claim is the untaken precaution when you talk about breach of duty, you're stuck with it. You can't change it when you get down to talking about whether it was the cause and fact of the plaintiff's harm. If you say that they should have provided life preservers on the boat when you're talking about breach of duty, then you're stuck saying they should have provided you're stuck asking whether if they would have provided life preservers, whether it would have made a difference, whether it would have saved the plaintiff's life. So you can't kind of switch those out. So that's something to watch out for. One other thing that I wanted to mention, something I sometimes see students do in exams, is they say the defendant should have used reasonable care. And then they say if the defendant had used reasonable care, would plaintiff have suffered the harm? Nah, she wouldn't have suffered the harm. That's a very easy kind of analysis, but there's no depth there. To say defendant should have used reasonable care, how exactly should he have used reasonable care? To say that the plaintiff wouldn't have suffered harm if reasonable care had been used, again, it doesn't really tell you what the defendant should have done, and it doesn't really tell you whether there is cause and fact. So you need to be specific. You need to identify specifically what the defendant should have done, so that when you get to cause and fact, you can say realistically whether if the defendant had done that, it would have made any kind of a difference. And sometimes there might be more than one thing. You could say defendant could claim that the defendant, plaintiff could claim that the defendant should have had life preservers on board, and she could claim that the defendant should have had netting left. And you can talk about how one will prevail on breach and the other one won't, and then talk about both of them again on cause and fact. So you can lay out different options. But if you're pleading a complaint, you're probably going to have to, you can plead in the alternative, but eventually you're going to have to stick to one thing. If a breach is found for failing to do one thing, then the question is going to be whether that failure was the cause and fact. Alright, so let's say you're on your way to school, and there's a guy driving in front of you, and he's an older guy, and he's driving a little bit more slowly than you would like him to. You're worried about getting to school late because, Professor Ford and Professor Dewey, they're crazy when people walk into their class late, and you don't want to be late. So you're tailgating the other person a little bit, maybe kind of a lot. And so you're going along there, and a drunk driver comes up behind you and rams into you, sending your car into the old man's car. Now, fortunately for you, you're not injured. Unfortunately for you, the old man is. So it looks something like this. There he is, there you are after him. Boom. Slams your car into the old man's car. Did the driver have a duty? Well, both of you had a duty. Did you breach your duties? Well, tailgating, it is against the law. It probably wasn't reasonable to be driving so close to him, although I'm sure we could argue otherwise. And the drunk driver, well, certainly that was a breach of duty, to be driving while intoxicated. So then the question is cause and fact satisfied? So if the drunk guy had not been driving drunk, would plaintiff have suffered the harm? Well, presumably if he had been sober, then he wouldn't have slammed into the back of your car, causing your car to slam into the back of the older gentleman's car. So, cause and fact, pretty easy to establish. Does that mean you're off the hook? Well, let's see. So if you, the tailgater, had not been driving too close, would the plaintiff have suffered the harm? Well, it depends. It depends on how close everything was. I mean, if the drunk driver was going fast enough, then maybe even if you hadn't been close to him, he would have sent your car into the older gentleman's car anyway. But then on the other hand, if you were tailgating pretty close and the drunk driver wasn't going that fast, maybe it was had you been further apart from the car in front of you, the old man would not have been hit. And so you can see the point of this little story is that there can be more than one but-for cause of an injury. Even though the drunk driver is much more at fault, at least you would want to argue, for this accident, it doesn't mean you're off the hook. And when it comes to damages through comparative negligence, the jury will decide who is liable for how much of the damages, who was greater at fault than whom. But that doesn't mean that you are not liable. The plaintiff still can state a claim against you because they can meet the element of cause and fact, even though somebody else was also cause and fact. So it's a very common mistake. Students think that if they find one person was the cause and fact, that another person's off the hook. or that a good defense is, it wasn't me, it was them. It's actually not a great defense, because the answer from the plaintiff is, yeah, you're right, it was them, and it was you as well. Okay, so most important thing is be sure to always apply but-for causation before you try out any exceptions. There's two exceptions that I want to focus on here first. Both of these are exceptions that come up when, for some reason, plaintiff cannot establish but-for causation, but courts have decided that even though there's no but-for causation, that they want to let it slide. They want to let the plaintiff have a claim anyway. So the first exception is alternate liability. This is basically a solution to a forensic problem. A solution to a problem when the plaintiff cannot prove which of the defendants was actually the one who caused her harm. So this comes from the Summers v. TICE case. In that case, as you'll recall, we had two defendants out hunting and the plaintiff out there as well. And there was a bird in the middle. And so the two defendants pointed their guns at the bird. The plaintiff was behind them. They knew the plaintiff was there. They probably shouldn't have pointed at the bird and shot their guns, but they were hungry, so they both shot. Boom. Part of some of the shot gets into the plaintiff's eye, and the plaintiff loses vision in that eye. So we've got two defendants who were shooting towards the plaintiff, and shot from one of the guns gets into the plaintiff's eye. Let's think about this for a second. How many negligent parties were there? We've got two defendants here. Both of them shot in the direction of the plaintiff. So I'd say there were two negligent parties there. Maybe you can argue the plaintiff was too, but let's just leave that off for now. Next question is, how many parties contributed to plaintiff's harm? Well, they both pointed their guns towards the plaintiff, but there was only one piece of shot that actually got in the plaintiff's eye. So unless both plaintiffs shot half a piece of shot that melded together and got in the plaintiff's eye, it only came from one of the two guns. And our big problem is we don't know which of the two guns it came from. So, how many of these parties contributed to the harm? Only one of them did. Problem is we don't know which one. So when we try to do but-for causation, if you see the first defendant, plaintiff would say, if defendant had not shot his gun towards me, I wouldn't have suffered the harm. And the defendant will say, no? Well, how do you know? If it came from the other defendant, then you would have suffered the harm whether I shot towards you or not. And of course the other defendant can raise the same defense and say, you know what, you don't know it was me or the other guy, it was only one of us, so you can't say more likely than not that it was him or me. 50-50 chance, so we both get off. The court did not want that to happen, so it came up with a rule called alternate liability. An alternate liability basically says when there's multiple defendants and only one of them caused the harm, the burden shifts to the defendants to show lack of causation if these three elements are met. First, all of the defendants were negligent. Second, all of the defendants are equally likely to have caused the harm. And it's impossible to know which defendant caused plaintiff's harm. Gotta have all three elements. Now, today, when forensics has made quite a bit of progress, and there's all sorts of ways of testing who did what came from which gun, and such, this doesn't come up that often. It's a favorite of law professors and occasionally shows up on the bar exam. In real life, it doesn't happen too often that you'll have more than one defendant who was negligent, equally negligent, and there's no way of telling which one actually caused the harm. Usually there'll be some evidence. But when there's not, we've got this. Let's try this out on an example. So this is a hypothetical from the second restatement of torts. It says that over a period of 3 years, A successively stores his furniture in a warehouse operated by B, C, and D. I love the way they give these people creative names. At the end of the time, A finds that his piano has been damaged by a large dent in one corner. The nature of the dent indicates that it was caused by a careless handling on a single occasion. That dent's telling you quite a bit. But in any case, so A wants to sue B, C, and D. The question is, can we use alternate liability? Well, let's first try but for causation. Let's see, but for the negligence of B, would the piano have been dented? I don't know. I don't know if B was negligent. I don't know what B did. I don't know whether it was B, C, or D. All I know is that one of the three of them did something, because according to the facts, they were the three who handled the piano over this time. So, but for causation, it's just not working. So we don't have enough information about the three. So can we use alternate liability? Well, for that, you need to have multiple negligent parties. Do we have that here? We don't know. B, C, and D, it doesn't appear that all three of them were negligent. They had the piano at different times, the furniture, it says, at different times, so we don't know. Maybe one of them was negligent, maybe another one was negligent. Maybe they all three were negligent. We don't know, though. And we certainly don't know that they were equally likely to have caused the harm. So the third element is met. We don't know which of them actually caused the harm, but the first two elements aren't met. So A still has the burden of proving whether the dent was caused by the negligence of B, C, or D. Alternate liability is not going to work here. Does that mean that the plaintiff loses? Not necessarily. What it means is that the plaintiff has to get more evidence. Plaintiff has to go to B and C and D and depose them and ask them what happened and get other witnesses and such to try and figure out when it was actually dented. And the jury's going to have to make a determination, a factual determination of who actually caused it. Okay, so another problem arises when there are multiple causes of defendant's harm. Now, very often when there's multiple causes of defendant's harm, but for causation works. So when you see multiple causes, multiple defendants, don't immediately jump to substantial factor. Wait. First look at but for causation. If that fails, then go to the substantial factor test. So, once again, there can be more than one cause of an injury, more than one but for cause, and more than one cause in fact of an injury. And it's not just when there's a person caused an injury and another person is also a cause in fact of the injury. It also happens where there's some force of nature that is a cause of the injury, and also a person is a cause of the injury as well. So there can be multiple but for causes of somebody's injury, even if one of them is not a human cause. So the Kingston case talks about two fires which were started. One of the fires was started negligently, and the other fire is believed to have been started naturally. The two fires joined and burned down Kingston's property. Kingston wants to sue the person who negligently started the fire. But he's got a problem. If the defendant had not had not started the fire, would plaintiffs have suffered his property burning down? The problem for the plaintiff is that if the defendant's fire hadn't burned down his property, the natural fire would have burned it down anyway. And so he can't show but for causation. He can't say, but for the negligence of the defendant, my property would have been just fine. So he's stuck. And since the two fires joined, it's really hard to tell what damage was caused by one fire versus another fire. If he could say that this fire, that they reached his house separately, and one fire burned down the garage and the other fire burned down the front porch, then great. Then he could separate that out and he could just sue about the garage. But since the two fires joined, they converged, he's in a difficult position. Before we try and find the answer to that, let's think a little bit more about how this would work if we change the facts a little bit. So let's say, same situation, we've got a negligently started fire and a naturally started fire, and we've got poor old Kingston with his property. Let's say the natural, instead of merging, the natural fire gets there first, burns the property to the ground. There's not two pieces of wood to stand on top of each other. It's burned to the ground when the negligently started fire arrives. Can Kingston sue for the negligently started fire? Well, certainly we don't have but-for causation. But for the defendant's negligent in starting the fire, the house was going to burn down anyway. We know that because it burned down before the fire even got there. And you can see this more extreme if we stretch out the time and say that the natural started fire got there 10 hours before the negligently started fire, burned it to the ground. The loss had already happened. So it doesn't really seem to make sense to have negligence in that case. Seems like in that case that the defendant's, I guess lucky, the defendant's not going to be held liable. Well, let's switch it up. Let's say the negligently started fire gets there first, and 20 minutes later, a naturally started fire gets there. And let's say we know that if the negligently started fire had not gotten there and burned the house to the ground, the naturally started fire would have done the job anyway. Was the negligently started fire a but-for cause of the harm? Well, this is interesting. You have to do the but-for analysis. So, if defendant had not negligently started the fire, would plaintiff's house have burned down? Yes, eventually, after 20 minutes in this case. But it wouldn't have burned down when it burned down. So in this case, we could actually say that the negligently started fire was a cause in fact of the defendant's house burning down. However, we can't say that the plaintiff suffered a whole lot of damages because the house was going to be burned down 20 minutes later by the natural fire anyway. This is kind of like the situation where somebody gets run over by a train, and the train gets run over by the train, they get killed, and the plaintiff just so happens to have only had a month to live. They had some terminal illness. Does it mean that the train's negligence was not the cause and fact of the plaintiff's death? No. It was still a cause and fact of the plaintiff's death. What it means is that the damages that the plaintiff's family can sue for is less, because the plaintiff was not deprived of many, many years of life, just about a month's worth of life. And the way that the law calculates damages, we look at things like earning capacity and projected length of life in order to decide damages. So it's good to distinguish that from the situation where we need to use an exception. But now let's get to that exception. Okay, so now let's say we've got two defendants. Both of them negligently started fires. And both those fires merged and got to the plaintiff's property at the same time. Now, plaintiff's in a situation because he can't show that either fire was the but-for cause of the house burning down. Let's compare this to the alternate liability situation for a second. How many negligent parties were there? Here, we got two, just like we did with alternate liability. How many of these parties contributed to plaintiff's harm? Well, now remember here, the fires merged before they got to the house, so they both caused some harm to the house. So we've got two. Remember, with alternate liability, the answer was 1. So let's try applying but-for causation here. If defendant 1 had not negligently started the fire, would plaintiff have had his house burned down? Well, defendant 2's fire would have gotten there, and maybe, probably, I don't know, it might have burned it down anyway. And then, of course, we can ask the same question about defendant 2. If he had not started the fire, would defendant 1's fire have burned down the house? So long as the fires merged, it's going to be really hard to say which one is the cause in fact, or if both of them are cause in fact of the harm, unless we can come up with some kind of exception. Maybe if one fire was very small, was very big, then we could say, well, no, this fire was the cause in fact. The other fire never would have done any damage. We would have put it out before it got to the house. But if both fires were big or equally sized, it's going to be difficult to show that. So we have the substantial factor test. So this is a second exception to but-for causation. When the plaintiff cannot show but-for causation because there was more than one cause of plaintiff's damages, the plaintiff can recover nonetheless through the substantial factor test if defendant's negligence would have been by itself sufficient to cause plaintiff's damages. So would that fire alone, if the second defendant hadn't started a fire, would the first defendant's fire have been enough by itself to cause the harm? If it is, then you can establish cause and fact through this. Notice how this is different from but-for causation. When we do but-for causation, we ask, but for the defendant's negligence, would the plaintiff have suffered the harm? And we don't change any of the other facts. If there were 5 negligent people, 4 of those negligent people keep doing exactly what they were doing. We don't pull them out. We just reach in and pluck out the one negligent party that we're working on and say, okay, if that party wouldn't have been negligent, would the plaintiff have suffered the harm? That's what we do with but-for causation. Here what we're doing is we're saying, okay, well that didn't work. So let's take all of those negligent people and throw them out and ask whether this one defendant's negligence would be enough all by itself to cause the harm. And if it is, we're going to hold them liable nonetheless. Okay, so I strongly recommend that you play around with those exceptions a little bit so you get used to them. A second challenge that often comes up with cause and fact in civil litigation is the realm of possibilities or probabilities, which come from expert testimony usually. Often there'll be a question, especially in medical malpractice cases, of what the likelihood of somebody dying was before the malpractice and what the likelihood was afterwards. Now, students sometimes get freaked out about this because it involves a very, very little bit of math. Trust me, it's not that hard. You only need to be able to multiply something by 2. Let me show you. So, now we're going to talk about analysis of probabilities under the but-for test, and then we'll briefly talk about the loss of chance doctrine. Okay. As we talked about earlier, plaintiff has the burden of showing that, more likely than not, the negligence of the defendant was the cause and fact of her damages. Basically, that means the plaintiff has to show that there's at least a 51% chance that the harm would not have occurred but for the defendant's conduct. Make it even more simple. Plaintiff has to show that the defendant's negligence at least doubled the chances of her suffering the harm. So, here's another case from the book. A sailor named Gardner fell overboard on a moonless night. It was not the captain's fault that he fell overboard. Apparently this just happens sometimes. But what the captain did do was fail to notice that Gardner was missing. And then when he did finally find out Gardner was missing, he didn't go bother looking for him. Gardner ends up drowning. He's never seen again. I'm wondering what kind of relationship Gardner had with the captain. But in any case, assume that the captain owed Gardner a duty, because there's a special relationship, and that the captain breached that duty by failing to even attempt a rescue. Let's apply cause and fact. We're going to do cause and fact. What are we going to do first? We're going to jump to an exception? No. We're going to first do but-for causation. If the defendant had attempted a rescue, would the plaintiff have drowned? That's the question. Well, it really depends. Kind of depends on the situation. Who knows if he would have turned around, if Gardner would have been still there playing in the water saying, "Hey, it's about time you guys came and picked me up." Let's ask this. Under which circumstance do you think it's more likely that the captain's failure to timely attempt rescue would be the cause and fact of Gardner's death? A, if Gardner fell overboard into shark-infested waters, or B, Gardner fell overboard into warm, blue waters. Let me attach some numbers to make it more clear. So, let's say Gardner falls overboard into shark-infested waters. He hit the water, they're coming at him already. Even if the captain had turned around immediately, there's only a 20% chance that Gardner would have lived. Was the captain's negligence in failing to attempt a rescue more likely than not the cause of plaintiff's harm? So did the captain's negligence more than double, by not turning around to go get him, more than double the chance of Gardner dying? Probably not. He was shark meat already. Gardner had an 80% chance of dying no matter what the captain did, because 20% chance of living means 80% chance of dying. I'll show you on a scale. So, if there'd been no negligence, Gardner had an 80% chance of dying and a 20% chance of living. Because there was negligence, he had a 100% chance of dying and a 0% chance of living. The question we have to ask is, did the negligence of the defendant at least double, I should say more than double, the chance of the harm happening? Here, you can't, since 100% is 100%, 80, you can't double 80 to reach 100%. He already was more likely than not going to be eaten by sharks, no matter what the captain did. Let's change it up a little. Let's say Gardner fell overboard into warm, beautiful blue waters. He's out there, he's enjoying himself. Now, if the captain had tried to rescue Gardner, there's a 60% chance Gardner would have lived. But the captain did not try to rescue him, and so Gardner sat out there in those warm blue waters till he got hungry and thirsty, and he tried to swim home, and he drowned. Under but-for causation, is it more likely than not that the defendant's negligence is the cause of plaintiff's harm? Here, it's a different situation. Whereas plaintiff had he had a 60% chance of living, which means he had a 40% chance of dying. So by not trying to save him, the captain increased his chance of dying from 40% up to 100%. And 40 times 2 is 80, so it's more than 50% more. He more than doubled the chances of Gardner dying. I'll show you my nifty scale here. On the left you see there was a 40% chance of death if there had been no negligence. You always look at the glass half empty when you're doing this analysis, otherwise you can get messed up. Whereas the likelihood of him drowning with negligence was 100%. So since the captain's negligence more than doubled the chance of the harm happening, there is cause and fact. Now the truth of the matter is this doesn't usually come up with sailing accidents and stuff, although you could certainly see that it could, but usually there's nobody willing to give expert testimony on the percentage likelihood and the chances of survival. But in medical malpractice cases, it's much more likely to come up. So, for example, plaintiff goes to see his doctor complaining of a headache. Doctor misdiagnoses the plaintiff, says, oh, you just have a migraine, take 2 aspirin and call me in the morning. A week later, the headache's still there, so the plaintiff goes to see a different doctor. The new doctor diagnoses plaintiff as having brain cancer. Plaintiff dies of brain cancer. Now this is an important fact. If the plaintiff didn't die of brain cancer, has the plaintiff been harmed? I'm not sure. You could say the plaintiff was harmed by not being able to know about it soon enough. But generally what we're looking at, especially when we're doing the numbers game where we're trying to see whether it was a but for a cause, we're looking at if the plaintiff died, then what's the likelihood that the negligence was the cause of the death? Certainly the negligence was the cause of him not finding out until a week later. Our question is, was the negligence the cause of him actually dying of cancer? And we know 2 things caused him to die of cancer. He died of cancer because he had brain cancer, and he died of cancer because he was misdiagnosed. What we don't know is whether it's more likely than not that if he had been properly diagnosed, he would have survived brain cancer. And so that's the question. What were his chances of survival when he first went to the doctor? Was he already 1 foot in the grave? Was he already going to die no matter what? Or if he had been properly diagnosed, would he have had a chance of survival? And even then, if he would have had a chance of survival, was it more than a 50% chance of survival? Because if it wasn't, then it's not more likely than not that the doctor's negligence was the cause of him dying. So, one way to set this up, I've given it to you in your assignment, a step-by-step process just to make sure you don't turn this stuff around. So when it's unclear whether the harm was the defendant's fault or whether it just would have happened regardless, you can use these steps. First, you got to look at, okay, what is the plaintiff complaining about? In this case, it's death. But whatever the injury or the harm the plaintiff suffered was. Then you ask, what is the likelihood of that harm happening if the defendant had not been negligent? Again, we always look at the the glass half empty and look at the likelihood of the harm. If this number is already greater than 50%, then defendant's negligence is not the but-for cause of the harm, because more likely than not, the person was going to die or suffer the harm anyway. If this number is less than 50, or 50, you can go on to the next step. Then you ask, what was the likelihood of harm happening when defendant was negligent? So, what's the likelihood that actually ended up because of the misdiagnosis? If this is more than double the number from step 2, then defendant's negligence is the but-for cause of plaintiff's harm. And I've given you guys some examples to work through to practice this. I think after you do it a few times, you'll see it's not quite that confusing, I hope. Now, some people really don't like this rule because they say, you know, that means that if I go to a doctor and I've already got a 50% or greater, or I should say greater than 50% chance of dying when I go see the doctor can be as negligent as he wants, and I'm never going to recover, just because I already more likely than not was going to die anyway. And so, in a few jurisdictions, and note that this is just a few jurisdictions, it's not the general rule, they've come up with the loss of chance doctrine, which says when there's a 50% or less chance that defendant's misdiagnosis caused the harm, the plaintiff can still recover a portion of the damages. That reflects the lost opportunity for survival that was caused by the defendant's misdiagnosis. As I say, you want to first do but-for causation, go through the steps we just talked about, and then as a footnote mention the loss of chance doctrine. Or if it's in a multiple choice question, check to see if they apply the loss of chance doctrine. If it doesn't apply, then we're back to our, is it more likely than not that the negligence was the cause of the person's harm. Okay, almost done here. So, now a quick summary. First, if I haven't said it 10 times yet, always try but-for causation before applying any exception. If plaintiff can't prove but-for causation, only if plaintiff can't prove it, you can use an exception. Notice these exceptions are for the plaintiff's benefit. They don't help the defendant. The exceptions, if there's but-for causation, the defendant can't say, yeah, but under the exception there's not but-for causation. It doesn't work like that. These are only for the plaintiff to use when the plaintiff can't show but-for causation. If there's only one party that actually contributed to the harm, but the plaintiff can't figure out which one it was, you can try applying alternate liability. It's pretty rare that it's going to apply, but it comes up sometimes. If more than one party or event contributed to the injury, apply the substantial factor test. Finally, don't freak out about the possibilities. Just look at whether the defendant's negligence more than doubled the risk of harm. Okay, so I hope this has been helpful. As a reward for your effort in listening to me for the past, 45 minutes or so, I have a limerick for you to help you remember but for causation. So, thank you.